Welcome all to this webinar by the Society of International Economic Law. It's called a SIEL conversation. And what we do is we have 1 hour conversation with experts from all around the world on topics of interest to the society. This conversation takes place all over the world, from Mexico City to Washington, D.C., to Amsterdam, Geneva, and virtual Singapore, although I understand Michael is currently in Geneva. And it's about sanctions and the rules-based international economic order. And it's going to be moderated by Vitaliy Pogoretskyy, who's going to be introducing the other participants. So I introduce him, representing the Executive Council of the Society of International Economic Law. And my name is Geraldo Vidigal, since you don't have it on your screens. And I'm an assistant professor at the University of Amsterdam. So Vitaliy is counsel at the Advisory Center for WTO Law in Geneva, where he advises developing country governments on WTO law matters and represents them in WTO disputes. Vitaliy previously worked as a dispute settlement lawyer at the World Trade Organization Secretariat in the Rules Division, and prior to that, as a private lawyer at the Brussels law firm and as a civil servant in the government of Ukraine. He's a member of the Ukrainian Bar, holds a master's from the WTI, from the World Trade Institute, and a PhD from the Center for Energy, Petroleum, and Mineral Law and Policy at the University of Dundee, United Kingdom. Vitaliy, the floor is yours.
Hello to everyone, and thank you, Geraldo, for inviting me to moderate this very interesting webinar with such distinguished speakers and competent speakers on the subject of our today's conversation. Let me briefly introduce our panel. Our first panelist is Ingrid Wuerth. She's chair of international law at Vanderbilt Law School and co-editor-in-chief of the American Journal of International Law. Ingrid has previously served on the State Department's Advisory Committee on Public International Law, and she is also a member of the American Law Institute and was named as a reporter for the Restatement 4th of the Foreign Relations Law of the United States. Our second speaker, Samantha Atayde, is partner at RRH Consultores in Mexico City. She previously worked for over 13 years for Mexico's Ministry of Economy at the Office of the General Counsel for International Trade, where she was involved in the negotiations on many regional economic agreements, for instance, the TPP, Pacific Alliance, and the USMCA. Samantha also represented Mexico before many international tribunals, such as the WTO and ICSID. Chuck Bown, our third speaker, is a senior fellow at the Peterson Institute for International Economics in Washington, D.C. His research focuses on international trade institutions and regulations, trade negotiations, and trade disputes. He's also the host of Trade Talks, which is a podcast about the economics of international trade and policy. Chad previously served as senior economist for international trade and investment in the White House, and most recently as a lead economist at the World Bank, where for 7 years he advised developing country governments on international trade policy. Last but not least, Michael Ewing-Chow, our fourth speaker, is associate professor and the WTO chair at the Faculty of Law of the National University of Singapore. He also worked in Allen and Gladhill, one of the largest and leading law firms in Singapore. Michael was involved in the negotiations on Singapore's early FTAs. He has been a consultant to the Singapore government, the ADB, ASEAN, UNCTAD, the World Bank, and the WTO. He also co-founded AIDHA, an NGO which provides financial education and microfinance opportunities for domestic migrant workers. Thanks to all of you for joining us today. If you have any questions to the panelists, please leave them in our Q&A box, and we will address them during the second part of this event. The subject of today's event is sanctions and the rules-based international economic order. In the past decade, there has clearly been a proliferation of economic sanctions. These measures have frequently been applied unilaterally by some states or organizations, such as the European Union against other states. They have been based on political or economic reasons, or applied in response on what was perceived as an unlawful conduct. The most notable and recent example of the sanctions are, of course, numerous economic and political measures that a great number of states and international organizations have taken in response to Russia's aggression against Ukraine. This aggression is in many respects unprecedented. It has been widely condemned as incompatible with the most fundamental principles of international law, including use cogents, for instance, by the UN General Assembly, the Council of Europe, and the Institute of International Law. In response to Russia's war, we have seen economic sanctions that were taken even by the states that have not previously taken such measures, including Switzerland and Singapore, as we will discuss with Michael later. Russia's war has also had a tremendous effect on the global economy, international trade, energy security, and food security, especially for many poorest developing countries and least developed countries, let alone devastating humanitarian consequences for the country of Ukraine and its citizens. The purpose of today's event is to explore the nature of economic sanctions, how they work from both legal and economic perspectives, in which circumstances they may be effective, and how compatible they are with the rules-based international economic order. So without further ado, I propose to start our discussion with questions to Ingrid as an expert in the public international law dimension of sanctions. Ingrid, by way of general introduction, general background, could you please explain what exactly the concept of economic sanctions means under international law and domestic law, for instance, US law? Can you please also give us examples of the forms that the sanctions typically take, and whether there are any legal limitations on the application of sanctions?
That's a big question. And let me start by thanking the conveners of this group and the participants. It's a great topic, and I'm excited to be here. So Vitaliy, as you've already said, sanctions are a very common feature of international relations. Yet despite the focus on them, and I think it's been a growing focus in the past decade, 2 decades, even before the events in the Ukraine, there's no real authoritative definition under international law. And even more than that, sanctions aren't really a distinct or discrete international legal category, at least across public international law. Instead, sanctions raise issues that cross disciplines, from trade to international investment law, to the laws governing international organizations, to state responsibility, countermeasures, erga omnes, retorsions, immunities, even the law of war potentially are involved. I think for our purposes, a good working definition for today is that international economic sanctions are coercive measures taken in response to an illegal or purportedly illegal action by a state. Sanctions can be taken by individual states, regional organizations, IOs, including the United Nations, and they can be imposed on individuals, corporations, state-owned enterprises, states themselves. Those different categories raise potentially distinct issues of public international law. To get a sense of the range of measures included in the term sanctions, we can consider, as you started to do, the measures that have been taken against Russia in response to the invasion of Ukraine. So we have sanctions on individuals, right? We have sanctions on individual decision makers in the Russian regime and in Belarus. That list includes, I think, in the EU, almost 1,000 people now. That includes President Putin and his daughters, Foreign Minister Lavrov, members of the Russian Security Council, military officials, members of the Duma, important Russian oligarchs, as we all heard through the news media, who support Putin. In terms of the kinds of sanctions we see, the assets of these individuals are frozen. There are secondary sanctions, meaning that other businesses can't actually transact with these individuals, and most of them are subject to travel restrictions. Then there are sanctions on Russia as a country, Russian state-owned enterprises, and private corporations within Russia. To some extent, those categories overlap. These sanctions run the gamut from the EU has closed its airspace to Russian air traffic, with some exceptions for humanitarian and diplomatic flights. Russian aircraft cannot fly over EU territory. Some sanctions are designed to counter Russian disinformation. So there's suspension of broadcasting activities by state-owned outlets, including Sputnik and Russia Today. Private companies are also prohibited from advertising on these channels. And then there's a set of well-known sanctions that aim to cut off the Russian regime from its currency reserves and from global financial markets. Those measures include banning transactions with the Russian central bank, banning trade and new Russian government debt. Other Russian and Belarusian banks, including some private banks, have had their assets frozen, transactions bans imposed, and they've been excluded from the SWIFT system. Some Russian state-owned enterprises can't issue securities on European exchanges, and some Russian businesses have been excluded from certain capital markets. So that's a big bucket of kind of financial sanctions. Then, of course, there are issues related to trade. These are efforts to reduce the income that the Russian state receives, again, in an effort to make it more difficult for Russia to finance its war. This includes countries that have banned imports on iron and steel products, cement, glass, wood, alcohol. Most controversial and important in this area, of course, are embargoes on Russian oil, natural gas, and petroleum products. The EU, for example, has not banned pipeline imports. And a ban on Russian coal, I think, is going to come into effect, but only after a transitional period. There are also sanctions that target the way that the transport of oil and energy is financed, insurance, technical support for Russian crude oil headed to third countries. Ships flying the Russian flag are not allowed to call in some countries at ports who have imposed sanctions. Again, these sanctions aim in part to increase the cost of financing the war. Many of them have been imposed across all G7 states. The idea, of course, is it makes it difficult for Russia to invade them. There has been an effort to design sanctions not to specifically target the Russian civilian population. And I think when we talk later about the policy objectives of sanctions, this, of course, is a really important issue in terms of how sanctions work and whether they're a valuable tool. So what legal limitations? And then I'll be quiet. We can turn to everything else. So there's not one like overarching legal limit where you go to the public international law on the thing that legal sanctions limit sanctions, and then you read through it, right? Instead, there's a set of legal limitations that varies sector by sector. Many sanctions may be perfectly legal, even if they're considered unfriendly retorsions. Some very important legal limitations are imposed by domestic law. Domestic statutes, for example, in the United States, impose a really strict bureaucratic framework for imposing sanctions. Domestic constitutions may limit the power of a government to confiscate or turn property over to someone else. There are regional and IO limitations. Of course, what the EU can do, for example, is in part limited by what the powers of the EU are. What the UN can do, of course, is limited by the veto of Russia and the UN Security Council. And then there are international investment and trade limitations. I hope to hear more from all of you on those topics. Bilateral investment treaties vary as between the EU, Canada, and the US. For example, there's a Russian-US BIT, but it's not enforced. And I'll be happy to talk about the area that I know the most about, which is immunities, which limit some kinds of sanctions, but not others. And so I'll leave it at that for now.
Well, thank you. This is very interesting. As you already started explaining, one form of sanctions is when governments freeze sovereign assets, which has also been the case during Russia's war in Ukraine. So there have been proposals to use Russia's frozen assets to rebuild Ukraine or to compensate war victims. Now, you wrote some interesting pieces on the extent to which foreign sovereign immunity would apply to Russia's, for example, central bank assets. Could you please elaborate more on the relationship between the freezing of sovereign assets and sovereign immunity? And in your view, is there any legal path through which the frozen assets of a sovereign state could be permanently confiscated?
Yeah, that's a great and very, very timely question. I think the most recent estimates are that the assets frozen by the US, Canada, Britain, Japan, Germany, and so on, amount to about $300 billion. That's a lot of money. And the Ukraine as a country desperately needs resources to fight the war, to rebuild, to respond to Russian violations of international law. So it makes some sense to look at that money that is just frozen and sitting there, that's Russian central bank money, other Russian assets, and think about maybe turning those over to Ukraine, which is the victim of Russian aggression. So in my view, freezing the assets, which is where we are now, does not implicate immunity. And here's why. Immunity is at its core a concept related to the assertion of domestic judicial power, right? Immunity, there are two kinds of immunity. There's immunity from suit, which means that Russia or Ukraine is immune from being sued in US courts. There is also immunity from execution of judicial judgments or immunity from other judicial conduct. A simple executive branch freezing of assets does not implicate immunity. Many people confuse this topic and say that it does, and maybe that would be a better way for the law to operate. But honestly, there's very little state practice that suggests that the mere freezing of assets implicates immunity. Now, it might violate international investment law. I'm not taking a position on those things. I'm just saying that the mere freezing of the assets by an executive branch doesn't implicate immunity. Once the assets get, however, confiscated and turned over to third parties, there aren't really countries that I know of that currently have assets frozen that allow that to happen without some kind of judicial process. And this is why there's an interesting overlay between domestic constitutional protections and the way immunity works internationally. So in the United States, you can't confiscate and turn over property to someone else without bringing into play the due process clause, and that will involve some kind of judicial action. Once you do that, I think immunity is fully in play, and I think a lot of the proposals to turn Russian frozen assets over to Ukraine or to injured individuals would violate customary international law on the immunity, especially when it comes to central banks. central bank immunity is near absolute, and I think these are violations of customary international law. I don't want to talk more. I'm happy to answer questions about how we might structure that in the way that imposes the least political costs or limits it, but that's where I come out. You really can't turn assets, confiscate central bank assets and turn them over to in a domestic legal process without violating immunity. I hope I got most of your question. You're muted.
Thank you. Yes, you did answer my question, and I have a follow-up here. So we heard about some legislative initiatives. For example, in Canada, I think that they have advanced maybe more than the other countries, than the US, the European Union, some legislative initiatives that seem to relate to how those frozen assets could be used to support Ukraine. Can you say a few words about those? Are they supposed to address these problems with diplomatic immunity? What is exactly proposed in those legislative initiatives? And
so
how far they are from completion? What will we expect at the end?
Yeah, so let me start by saying that in my view, the United States has violated foreign sovereign immunity in the way that it has treated Iranian assets in the past, and perhaps in the way that it has treated Venezuelan assets in the past. So I don't want to suggest that violating foreign sovereign immunity in relation to central bank assets would be totally new or unprecedented. I believe that unfortunately my government has set a precedent for doing so. So there are other examples, and in fact, this used to be part of the Iranian ICJ case against the United States, but the foreign sovereign immunity part was thrown out on jurisdictional grounds. So there is some precedent. As you said, the place where it has advanced the most with respect to Russian assets and the invasion of Ukraine is there is Canadian legislation that would allow sanctioned Russian assets to be turned over on behalf of Ukrainian war victims. As I understand it, it sets up a procedure that involves the executive and the judicial branches of the government taking part. And here's the way Canada is trying to kind of limit this. I think precedentially, the law requires a grave breach of international peace and security in order to come into play. If that is true, then this unilateral step can be taken. As far as I know, Canada hasn't actually started turning assets over to people under the law, but Canada is clearly has the law in place. Measures in the EU, as far as I know, have stalled. There was a lot of push in this direction in May and early June. As far as I know, there has been no further legislative process. And I would just note the obvious point that, you know, once we start unraveling immunity for central bank assets, it's hard to limit that precedent, perhaps. And I do want to also note that I think current circumstances are very compelling, and so it's not out of a lack of interest in helping victims of Russian aggression.
Thank you very much, Ingrid. I would like to ask now a few questions to Samantha on how economic sanctions are regulated under WTO law and investment treaties. In the past few years, there has been an increase in economic sanctions in the WTO. One example are the Trump's tariffs on a wide range of Chinese goods in response to China's state capitalism. We have also seen the exchange of sanctions among different members of the Gulf Cooperation Council. Again, as we discussed, most recently, many states and the EU have sanctioned Russia for excluding goods of Russian origin from their WTO preferred tariffs. Russia-related assets have been frozen. The EU authorities also denied certification for Russia's very expensive and nearly completed Nord Stream 2 gas pipeline. Samantha, in your view, what is the regulatory scope for states to apply these measures under both WTO and investment regimes? And can states apply any sanctions in the time of a war, for example, the current war between Russia and Ukraine, or are there any limitations?
Thank you, Vitaliy. Good morning, everyone. I would like to thank the Society of International Economic Law for the invitation to this conversation. It is my pleasure to be here. Well, going to your question, first, I think it's necessary to distinguish the nature and reasons that motivate the application of unilateral measures. While some of these economic sanctions that you just mentioned that we have seen over the last few years were used to pursue policy goals related to the compliance with trade rules, others have resulted from different objectives that for some escape the scope of the WTO. Notwithstanding the reasons for the imposition of economic sanctions, for the vast majority, the justification relies on the national security exception. Although the legality of unilateral measures or sanctions could be debatable in public international law, in the multilateral context, the consistency with the WTO rules and the justification invoked by WTO members in question could be challenged under the dispute settlement mechanism. This possibility existed until the WTO had a functioning mechanism. As we know, for over 23 years, the dispute settlement mechanism was considered the crown jewel of the system. Unlike other international tribunals, this one proved to be a practical forum for the resolution of disputes with good outcomes in terms of implementation of panel reports. The Ukraine-Russia conflict resulted in the imposition of unilateral economic sanctions of important magnitude, not only between Ukraine and Russia on each other, but also several WTO members had imposed restriction on goods and services from Russia, and Russia as well has adopted retaliatory measures against its members. The WTO has recognized that this conflict is added to a list of factors that negatively affect global trade recovery after the pandemic. Since both countries are important suppliers of commodity, the impacts in trade are important. So to respond to the specific part of the question, in the context of the WTO, the imposition of economic sanctions provide grounds for WTO challenges. However, at this moment, there is uncertainty in the adjudication of any of these challenges, and there is also uncertainty in the adoption of any outcome resulting from them. For example, recent disputes submitted by Russia against measures by the EU prior to Ukraine's invasion were appealing to the void. And also, since the tension began between Ukraine and Russia, they have also submitted disputes under the dispute settlement system. Setting aside disputes concerning with trade remedies issues, the dispute in Russia traffic in transit is relevant for this discussion. This was the first dispute in which the WTO panel was asked to interpret the security exception contained in Article 21 of the GATT 1994, particularly paragraph B, numeral 3. The panel findings in this dispute are illustrative in matters that have been under debate, such as the jurisdiction of the panel to review the exception and the self-judging nature of the exception. These findings provide some guidance for future disputes if they are adjudicated. In this dispute, for example, the panel found that the requirements to invoke the security exception were met for all the claims. But also, it's another dispute is illustrative for this discussion. This dispute involved Qatar and Saudi Arabia. The panel was also asked to interpret the security exception of the TRIS agreements. What the panel did, it followed the analytical framework developed by the panel in Russia traffic in transit and found that for one of the measures, Saudi Arabia did not meet the requirements to invoke the security exception. Although Qatar and Saudi Arabia agreed not to adopt the panel report, the panel made interesting conclusions about the discretion of a member to designate particular concern as essential security interests and the connection that those interests must have with the measures at issue. Moving to the investment claims, we have that according to the 2021 World Investment Report, Russia remained the largest recipient of FDI in the region, accounting for more than 40% of influence. In response of the economic sanctions as a result of the Ukraine's invasion, Russia also adopted retaliatory measures against foreign investors and their investments from what Russia designated as unfriendly states. Actions include, for example, restriction of the transfer of foreign currencies, restrictions on the transfer of shares, securities, and real estate transactions. Now, Russia has 63 bilateral investment treaties that include some of the states designated as unfriendly. Without prejudice to a detailed analysis on the legal standing and scope of each of those BITs, investment obligations that could be at stake include fair and equitable treatment, expropriation, and discrimination both on MFN and NT grounds. Under these BITs, foreign investors may have a recourse to investment arbitration to seek compensation. Since in some of the Russia's BITs have a limited scope, it will be likely that those foreign investors seek MFN provisions to bring obligations that otherwise will be not covered. However, it is important to note that the case law is not uniform in this respect. Another important issue to keep in mind will be whether those VITs contain express clauses either on national security or non-precluded measures or denial of benefits. And finally, a couple of things to also keep in mind when it comes to investment arbitration is that Russia does not have a history of voluntary compliance of awards. This includes challenging awards in domestic courts at the seat of arbitration and resisting enforcement in several jurisdictions. And also, many of Russia's assets are frozen, as Ingrid just mentioned. So investors will have to undergo additional procedures in the states in which they seek enforcement to get license or authorizations from the competent authorities to the release of these assets. Nevertheless, they are already examples of Ukrainian investors as well as investors from other countries that have already announced that they are considering starting treaty arbitration. And I will leave my comments here.
Sorry, forgot to unmute. Thank you very much. Not only did you explain the regulatory scope under WTO law and the investment treaties, but you also provided examples of possible legal proceedings that now may unfold because of the current war between Russia and Ukraine, both on Russia's sides and in other jurisdictions. Now, there is yet another dimension of sanctions, another context completely different, the US-China trade war. There has been an exchange in WTO complaints between these members. So one could mention here the US tariff measures dispute or the Section 232 disputes in the WTO brought by many complaining parties against the US, and the US actually made some challenges against those parties' countermeasures. Now, would you like to comment on how this trade war has unfolded and who is winning? Also, have there been any developments on the investment treaty arbitration front of this trade war between China and the United States?
Yes, thank you. Very briefly, and just a couple of considerations to follow. The first one is that this trade war has resulted in the so-called trade deals between the United States and China. So it is important to see the results and the scope and the WTO consistency of these trade deals. Since China and the United States are the major players in the WTO, it is uncertain if this kind of settlement will set a precedent and the implications for the system. Two, the role of the WTO rules. The United States has stated that the WTO is an inadequate tool to address some of its concerns. The latest report on China's WTO compliance issued by the USTR refers to new strategies that include solutions independent of the WTO. So it's important to have in mind that. And finally, to follow trade commitments that the US is undertaking with partners in bilateral or regional agreements. For example, the USMCA or the Trade and Technology Council between the US and the EU, and this announcement by the USTR to have a possible agreement with the Indo-Pacific region countries.
Thank you very much. Chad, I have some questions to you on the economic effect of sanctions. You have studied extensively these effects from multiple angles. For example, as I understand, you have both academic and practical experience in WTO retaliation proceedings when a respondent fails to comply with a WTO ruling. You have also written and spoken a lot on Trump's tariffs. What are the economic channels through which sanctions normally work? And based on your experience and available data, have economic sanctions ever been an effective policy tool to enforce international law, at least in the WTO context?
Thanks, Vitaliy, for this great question. And since we're kind of running short on time, what I'm going to do is I'm going to try to answer those questions, and then I'm going to anticipate your follow-up question about what's going on in the Russia-Ukraine context, so I can condense it all quickly, so we can quickly turn it then over. You can stop following up with me and go directly to Michael, so we don't lose him there. So I think the short answer is in the history of sanctions, they've kind of had mixed results. In WTO, sanctions in particular are extraordinarily limited. I think one of the benefits of the trade dispute system is it really, in a sense, it's designed to contain and prevent a particular small trade dispute from spilling over and spiraling into a trade war, right? And so that's why we look at the specific economic implications of the first measure, that's the WTO violation, and limit the rebalancing to kind of just that amount of say, trade or economic effects. This story, I think, is incredibly different. And and now I'm talking about Russia and Ukraine. And so first, let me say thanks for the invitation to be here. Second, I am an economist, not a legal scholar. And so I love all of you. But what I'm going to say is probably going to be inconsistent with legal stuff. So forgive me. But third, what I have been doing, and is sort of an advertisement, my response to the tragedy of war is to compile data. And I know that's not particularly useful, but hopefully it's useful to folks that are on the webinar here. And so at the Peterson website, we've been tracking essentially all the sanctions that have been evolving since the beginning of the crisis in war. So that's all public, and please use it, help us make it better, et cetera. But in my examination of that, and then looking at the economic data, so the question of, are the sanctions that have been imposed so far, and there are a massive amount, are they having an economic effect? That's sort of the question that everybody wants to know and to answer. And my answer to that is yes, but. And the but is, it's really hard to see, and it's going to be really hard to disentangle which economic effects are necessarily associated with which kind of sanctions, and to be able to explain that. And there's going to be secondary things happening on, there's going to be unintended consequences and all of those kinds of things too. And so let me just walk through a couple of reasons why there, and then we can move on. So first is, Russia has shut down a number of kind of standard data series that they don't publish anymore. And so it's really hard to see economic effects if the data that we use to sort of indicate them are no longer being published. So that's one problem and challenge. Two, prices change. So in the really important issue of, suppose we shut down or limit Russia's exports to the world of energy, oil, natural gas. Well, that has volume effects, right? So there's a fewer barrels of oil or whatever BTUs of natural gas that are showing up But when the prices of those things go up tremendously, the revenues may actually increase with the sanctions, or profits of the state-owned enterprises may actually increase. And so, it's hard to kind of disentangle these things. Not only with prices of the commodities change, but exchange rates change as well, right? And so we've seen these extreme movements in, say, the ruble dollar exchange rate over the course of the crisis. Initially, there was a massive depreciation of the ruble. There was concerns within Russia that this could lead to run on banks, the stock market collapsing. But, since March, April, there's actually been a stunning and somewhat puzzling appreciation of the ruble. And so the question is, what's going on there? Is that even a useful economic indicator to even look at for us to learn about anything having to do with the impact of the sanctions, the health of the war? I think the short answer to that is it's evidence of an impact. In some sense, Russia can now export things still. We haven't imposed bans on yet Russian oil and natural gas, so they can still export, but they can't import, right? We've got all these export sanctions being imposed by the United States, by the EU, preventing technologies from getting there into Russia. And so that's led to this imbalance, which has then impacted the exchange rate. Third or fourth, Russia is undertaking its own policy responses when being hit with these sanctions. So obviously its central bank has initially raised interest rates substantially, imposed capital controls. So it's not just sitting idly by there, it's imposing its own policies in response. Other reasons, some of these sanctions are designed to have, or can really only have, long-term effects. So export controls that are designed to, say, degrade the capacity of the Russian military or its industrial complex to be able to wage war by cutting off semiconductors, cutting off other critical inputs. Well, there's going to be a period of time in which it takes for that to kick in, right? They may have stockpiled some of these things that they're going to have to work through their stockpiles before that ultimately has an effect. And then finally, when we look at some of the external indicators, it's also tricky as well. So there has been some folks that have looked at mirror statistics, say, okay, so Russia, we don't have good data anymore on Russian imports and exports, but we can look at other countries' exports to Russia and infer something from that. And so we're seeing that, yeah, even countries like China, their exports to Russia have fallen sort of in line with the sanctions that have been imposed by the United States and Europe. And the question is, well, maybe that's evidence that China is actually complying with Western sanctions, even though it hasn't announced imposition of its sanctions of itself, right? Maybe it's China ships a lot of semiconductors and tech stuff, so maybe it's actually complying. It's hard to say, because we have to remember that within Russia, there's been a huge negative demand shock to their economy. And so they're just buying less stuff, and they're going to be buying fewer imports from everyone. So disentangling the economics of all of this stuff is going to be really hard. So be patient with us economists as we help to try to figure it out. And with that, I'll try to stop. But thank you for the invitation, and congratulations and thanks to my co-panelists for all their great work and really insightful remarks this morning.
Thank you very much, Aris. It's always interesting to also understand the economic dimension of economic measures, to see whether the measures are actually working or not working, and how they should be adjusted if necessary. On that note, I would like to ask some questions to Michael about the geopolitical dimension of sanctions. Michael, as I understand, Singapore has traditionally imposed trade sanctions only according to UN resolutions. The Russia-Ukraine war is, however, an exception here. Can you please tell us a bit more about how Singapore responded to the war, and why, in this case, Singapore's government has decided to deviate from its normal practice?
Yes, first, thank you for inviting me. And I think at this time of the pandemic, the war, it's good to see old friends again. I see people on the list of attendees, which I very much look forward to see during better times. And I think it's important for us to get together, even in these difficult times, to deal with things. Singapore, traditionally, as you said, only does it when it is approved by UN resolutions, because Singapore believes in international law and doesn't like to have aberrations or sort of departures from the ordinary rule of law. However, in this case, as you said, it's an egregious situation. The sovereignty and political independence and territorial integrity of all countries is taken very seriously by Singapore. Because obviously, as Singapore is a very small state, the fact that we all believe in this normative standard is important for survival of Singapore. So the MFA, the Ministry of Foreign Affairs in Singapore, is on record saying that Russia's invasion of Ukraine contravenes the UN Charter. It's a clear and gross violation of international law, and is a dangerous precedent. Therefore, Singapore took the unprecedented step, imposing trade sanctions, because Singapore recognizes this was a situation that was almost unprecedented since World War II. Here, a permanent member of the Security Council, Russia, is the aggressor and the gross violator of laws against the use of force. And Russia vetoed the UN resolution, so there's no chance of a UN resolution. This is why Singapore has joined in with sanctions aimed at constraining Russia's capacity to conduct war. Singapore imposed export controls on items that can be directly used as weapons to inflict harm on the Ukrainians, as well as items that contribute to offensive cyber operations, so dual-use items. Singapore also imposed financial measures targeted at designated laundry lists of Russian banks, entities, and activities in Russia, and fundraising activities benefiting the Russian government. These measures apply to all financial institutions in Singapore, including banks, financial companies, insurers, capital market intermediaries, security exchanges, and even digital and e-commerce payment service providers. However, even though we did do this, and this is quite broad, I don't think the sanctions as they are that's imposed by Singapore or by the coalition of the Western allies at the moment may by themselves not be sufficient. They cannot stop Russia from conducting the war or encourage a regime change in Russia by themselves. And I recognize what Chad says, that we don't really know, because in many ways we're in a fog of war. But from experience, having looked at it from other situations of sanctions, often find that they don't work as well as we hope they would.
Thank you. Are you referring to a potential sanctions leakage, meaning that Russia may also impose some adaptation measures to circumvent sanctions? Could you elaborate a little bit on that point, maybe?
Yeah, absolutely correct. So I first started looking at sanctions and trade way back in 2003, when the US passed the Burma Freedom and Democracy Act, which froze assets of junta members in the US and sought to prevent remittances to Burma. I used at that time to go to Burma, a founding member of the GATT, by the way, to teach them about law and WTO law in particular, at that time as part of a capacity building outreach program of ASEAN and Singapore. And I saw firsthand the harm the sanctions caused to an average citizen, and saw that sanctions actually allowed the junta to tighten the grip on the country, because the junta could access the black market and earn hard currency, whereas a small average businessman or worker could not. So when George W. Bush renewed the Burma Freedom and Democracy Act in 2006, I wrote an article called First Do No Harm, suggesting that sanctions should be targeted at officials and certain companies, and that generally broad economic sanctions, for example, in the case of human rights violations in Myanmar in 2006, not today, may cause more harm than good. I will repeat the words of Senator Baucus in 2006, commenting on the BFDA. The arguments against economic sanctions continue to be quite compelling. First, they have a very poor record of success. The kinds of government that merit this sort of treatment are not sensitive to international disapproval, nor are they swayed by it to make changes. Second, economic sanctions tend to hurt the people that they intended to help. Ordinary people lose their jobs, while the military and leaders are often left untouched. Third, severing economic ties cuts off an important avenue of dialogue that could potentially promote change. I personally think that sanctions can work if you cut off all supplies of military materials or money to fuel the military regime currently in Russia. The problem we face today, as you correctly point out, is that sanctions on Russia are not universally adopted. There is significant leakage because some major economies continue to trade quite actively with Russia. Thus, the sanctions do not by themselves prevent the war. It may cause some inconvenience, as Chet suggested they could perhaps done, but the ability of Russia to continue to conduct the war, I think, continues. In the meantime, by cutting off Russia and its people, it may just strengthen the grip of the current powers that be in Russia on Russia.
And how do you think this sanction leakage could be addressed, Michael?
And now come to the part where I have to say I really don't know. I have some ideas and suggestions, but I would love to hear other people's have thoughts about it. We've tried many things over the years and not many things have worked, unfortunately. But here are some thoughts. So first, I start with the idea, first do no harm. My main message is that while sanctions are often resorted to by politicians as a response to terrible situations, we must first determine if our sanctions really help or hinder a situation. Now, I think there are two main differences between the Myanmar situation in 2006. Again, I say not the Myanmar situation today, but in 2006 and Russia today. Even the countries still actively trading with Russia do not attempt to justify or normalize the egregious violations of international law by Russia. Everybody agrees that this is wrong. Second, the objective of the sanctions, as opposed to the Myanmar situation, here you're just crippling the Russian war machine, is a clearer target. So if you just want to cripple the war machine rather than effecting change in human rights, whatever that may be, in a particular country, it is a clearer target with clearer objectives. So while I'm very reluctant to advocate for increased deviations from normal trade and commerce, considering the difficulties the world already finds itself with the shortages because of the pandemic and the effect on global value chains, climate change, we have to balance the dangers of destabilizing the regime with the clear and present danger of Russian aggression. This is an almost universal denunciation of the actions of Russia, even the countries are trading with it, but not universal uniformity in the response. Now, it could be over time, like in the South Africa case, and I'm sure Chad would be able to tell us more about that if asked, that eventually over time, convergence towards a common response can eventually develop. And that took a long time, more than 20 years in the case of South Africa. We just do not have the luxury of time today. Now, I still do not encourage broad, non-targeted sanctions just because we want to assuage our conscience in the face of impotence to do anything. However, I think a carrot and stick approach to cut off the flow of money and military material to the Russian war machine could be an option. A focus of sanctions could be on the movement of money in the global financial system to stop the leaks. If a particular bank in a particular economy continues to facilitate that leak, and here I'm very cautious, and I know it's controversial, I think such a bank could potentially be seen as a collaborator and be subjected to sanctions itself. Trade in goods and food, for example, should still continue to flow. We need this trade in goods and food, but the money could be kept in escrow until the war ends, perhaps defined by Ukraine or independent third party. And trade in military materials, dual use of products, and money to the Russian war machine should be targeted and stopped. I think this is entirely justifiable from a GET Article 20A public morals perspective, or even a GET Article 21 argument, since it will probably pass a good faith test of the Russia transit case as an action which it considers necessary for the protection of its essential security interests, basically a response against a continued illegal use of force, and taken at a time of emergency and international relations, which is clear. Now, trade sanctions alone will not stop the war, but we can attempt to reduce the harm they cause to non-combatants and target our attack on the actual war machine and those responsible for running it. This will also be more easily justified as a proportional measure. So I hope that answers your question.
Thank you very much, Michael. These are very interesting ideas, and I haven't heard them before. I have a very quick follow-up question from the audience, specifically addressed to Chad by Peter van den Boscher. So he's asking whether there is any information on the impact of the sanctions on the economy of the countries taking the sanctions. And then once, Chad, you answer, then we have maybe around 3-4 minutes. We have to be super organized to just go through some maybe 1 or 2 questions from the audience, maybe in the reverse order. Chad.
Great question, Peter. No, the data takes a while to come in, and doing it carefully, though I think obviously the biggest indicator is the inflation measures that are certainly being impacted by this here in the United States and in Europe as well. Though how much of the inflation can be attributed directly to actions that Russia's taken, the sanctions themselves is up for debate, but they're certainly being impacted.
Great, thanks, Chad, for giving this very brief response and answering the question. So I will just read out several questions and propose to all of the panelists, and you can address them in the reverse order if you think that this relates to your expertise. So the first question: is it allowed to arrest and confiscate the private property of Russian individuals and legal entities without any judgment under international and domestic law of the US? Then the next question is whether this type of unilateral sanctions that we discussed are lawful in the current public international system, or at least is this how the original drafters of the UN Charter perceived the international economic order, where countries would just impose unilateral sanctions outside the Security Council? And then there is also one question about an Italian precedent where the Italian Constitutional Court admitted that in certain cases immunity could be lifted if there is a gross violation of Constitution. And the author of this question suggests that this may be inconsistent with public international law. But he is asking whether this type of precedent could be used in the context of Russia, of the Russia war, of the Russia-Ukraine war. So I let everyone comment on this briefly. I understand that most of these questions are maybe addressed to Ingrid, but there is at least one, I think, question which is more general. So Ingrid, would you like sort of to tackle them, and then I will see if someone else.
I'll talk really briefly, and then we can see what other people might want to say and what there's time for. So on the Italian, the Farini judgment, which does, as the author of the question note, go against a judgment of the International Court of Justice. There, the idea is that immunity can be lifted for use cogens or gross human rights violations or constitutional violations. I'll just say, if we're going to allow central bank immunity to give way for human rights violations, that's a huge, I have a lot of respect for the Italian position. I think that the German war crimes on Italian territory, which were the subject of the Farini action, were terrible. But the general idea that human rights violations or even use cogens violations provide a basis for lifting central bank immunity, I think is a huge step. And we just need to think really carefully about human rights and the international economic order before we take that. More generally, and this goes a little bit to some of the other questions, I didn't mention countermeasures. And so one question is, why can't the lifting of immunity, the abrogation of immunity, including central bank immunity, be understood as a countermeasure taken by third-party states in response to an erga omnes violation? The erga omnes violation, of course, is the invasion by Russia of Ukraine. I think that's a very interesting topic. Countermeasures haven't been extended that far, and so it would be a step. It would be a real step. And I'll just note one thing about countermeasures. Countermeasures are usually thought of as designed to induce compliance and to be reversible. The idea of the countermeasure is, we're going to withhold our compliance until you get back into compliance, and then we will start getting in compliance. Once you turn assets over, you confiscate them and turn them over to third parties, that's not reversible. That's not, and so it falls a little bit outside typical countermeasures. The other thing I'll say is, take the Canadian legislation. Canadian legislation allows the confiscated assets to be used to compensate victims. How might those victims, and there's a state sponsor of terrorism designation in the United States, and if we use a state sponsor of terrorism designation, US citizens, US nationals who are victims of Russian aggression in Ukraine, to the extent there are US victims, they would get the first take at that money. And so to me, the idea that we would use countermeasures to allow the United States to seize Russian central bank assets and then turn them over specifically to American citizens and American corporations who were harmed, rather than Ukrainians who are harmed. These are some details that I think are really, really important. And they seem to move pretty far from what we would normally think of as countermeasures. And I'll stop, but I'm happy to say more too.
Thank you very much, Ingrid. Very interesting observations. I think we are running out of time. Geraldo, can I give 1 minute to Michael and Samantha each to maybe sort of address that general question of the consistency of this unilateral sanctions with the rule-based system rather than sort of UN system, and more specifically, just if you have some observations on that point. This would be useful.
So as I said before, I think there's a great need to always do things where possible with proper processes and rule of law. UN system would be a good one, but unfortunately we don't have this because it's vetoed. So in light of that, some sort of multilateral, even sometimes unilateral action may be necessary. As we said before, as Ingrid suggested, it could be a countermeasure, but countermeasures also have to be necessary and proportional. And we need to think about ways in which we can make them a little bit more uniform so that we don't affect the non-combatants, the normal Russian people, and focus upon our attention to the Russian war machine and the Russian authorities. And we can do that working together. And we've been responding in sort of an emergency crisis mode. So everybody's just running around trying to do it as fast as we can. But over time, and this will take a long time to deal with, we can try to increase our communications, our collaborations, our coordination. I think that's important.
Thank you very much, Michael. Samantha?
Thank you, Vitaliy. Very briefly, well, in the context of the WTO, the main concern is that the mechanism is not properly functioning right now. As we know, it's under certain challenges. So we don't know if any dispute could be adjudicated in that forum. And on the investment side, one of the questions mentioned the sanctions against Russian citizens and enterprises. This involve asset freeze in some jurisdiction. Well, these citizens and enterprise may bring or potentially bring investment claims, and if they satisfy the requirements of the VIT in question. But as Ingrid mentioned in the beginning, there is no VIT between Russia and the United States. I mean, at least not enforced. But from other states, there might be a recourse there. But we also have to take in mind that the defenses will include the security exceptions or the denial of benefit clauses, or if not, states will seek customary international law principles.
Thank you very much. So on that note, I would like to thank all of their speakers for their excellent interventions, for taking their time from their busy schedules to join us today. I would like to thank the audience for asking very good questions, for attending this event, and also Geraldo and SIEL for organizing this very interesting session. I pass the floor back to you, Geraldo. Thank you.
Thank you. Okay, this will be enough. Thank you very much, Vitaliy. Thank you so much for all the participants for their fantastic questions, the fantastic points, and for the audience, for their audience and for their questions. I have one review to make, I think, prompted by Michael's comments and authorized by one of Executive Vice Presidents, which is the location of the 2023 SIEL convention or conference, which is going to be in Bogota, Colombia, led by in a consortium of universities led by Universidad Externado. Those of you who are in international trade law know that Colombia is a powerhouse in international trade, and now, of course, boasts also the fact that Ambassador Santiago Wills has managed to get an agreement on fisheries. So it's going to be very interesting, and I very much look forward to seeing you in Colombia next year. Please follow SIEL on Twitter, at SIELnet. And if you aren't members yet, please join SIEL as members. We have prizes for students and early career researchers that we very much hope will attract you to our society. Thank you very much, everyone.